into the courtroom and is now seated at the defense table. Mr. Ringstrom, why don't you go ahead and tell me what the terms of this pretrial agreement are?
Yes, Your Honor, we have offered to Ms. Hall, if she pleads guilty to possession of meth as count one, that we will dismiss to have four. It's my understanding she is willing to take that. People definitely are not in any objection for her being able to go to rehab.
Thank you. Mr. Champion?
That is my understanding of the plea agreement.
All right, thank you. Ms. Hall, is that how you want to proceed today?
Yes,
Please raise your right hand to the best that you can. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
yes.
You may lower your hand. All right, Ms. Hall, looking back on July 25th of 2025, were you on probation, parole, or bond at that time?
I was on, no, I was not.
All right, thank you. Now, you are currently charged on a felony information with a single count. That count is possession of the controlled substance methamphetamine, which is a felony punishable by up to 10 years and or up to $15,000. There's also what's called a fourth habitual felony offender enhancement that is listed. That means that if you were found guilty, the court, your potential sentence could be increased from up to 10 years to up to life. However, I'm told today that you're going to enter a plea of guilty to count one, possession of methamphetamine, and the prosecutor will dismiss the fourth habitual felony offender enhancement. Is that what you understood?
Yes, sir.
All right. Now, by entering a plea of guilty, you will not have a trial of any kind. Does that make sense, ma'am?
Yes,
By entering a plea of guilty, you'll be given up certain rights that you'd otherwise have in a trial. That includes, of course, the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at the trial, the right to remain silent during the trial, the right to not have silence used against you, and the right to testify if you choose to testify. Do you understand those rights?
yes,
And even more importantly, you understand that if you enter a plea of guilty today, and I accept that plea, you will be forever waiving those rights as they apply to this particular case.
yes,
Thank you. Additionally, any appeal as to the plea and the sentencing, which are pursuant to a pretrial agreement, would be by filing what's called an application for leave to appeal and not an automatic or claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You also will be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Do you understand?
yes.
Have there been, other than the terms of the agreement, any other threats, duress, coercion that get you to plead guilty that we haven't talked about today?
No, sir.
Are you entering the plea therefore of your own free will?
Yes,
Now, on this written pretrial agreement that hasn't been signed by you, but I trust Mr. Champion has gone over it with you. Oh, wait, is that your signature, Mr. Champion?
It is, Your Honor.
All right. It suggests that the council have reached an understanding that they believe that an appropriate sentencing guideline range would be between 10 and 23 months. That is an estimate. Do you understand?
yes,
All right. And in other words, it's not a promise exactly as to what that guideline range would be. Do you understand?
mhm,
And do you understand that any estimate of guidelines here, it's up to the court to determine the sentence? Do you understand that?
yes.
And has anyone made any promise to you as to exactly what the sentence would be from this court?
No, sir.
All right, thank you. Knowing all that, do you still wish to enter the plea of guilty that we talked about earlier?
Yes,
As to count one, a possession of the controlled substance methamphetamine, how do you plead?
guilty.
Before the court can accept that plea, I need you to tell me what it is that you did that makes you guilty of that offense. So turning your attention back to January 25th of 2025 in Lake Township in Missaukee County. What happened?
I was at Friends Ministries, a police officer pulled in. I was dumpster diving from there. And furthermore, he did a vehicle search and he found a substance which thought was to be crystal methamphetamine.
All right, did you know it was crystal meth?
Yes,
And where was it on you?
it was on the council inside the vehicle.
All right, and you knew it was there?
Yes,
And you knew that it was methamphetamine?
yes,
And again, it was in your possession or area of control?
yes,
And in your mind, did you have any lawful right to possess that controlled substance?
no, sir.
All right, thank you. Mr. Ringstrom, do you believe she has provided an accurate description of the events
I believe she has, Your Honor. very
satis-
truthfully.
and satisfied the elements?
She has satisfied.
All right, are you aware of any other promises, threats, or inducements?
No, Your Honor, I will inform the court that looking at her criminal history, she is 7411 eligible. I know Mr.
Okay.
Champion will argue that. You probably won't be objecting to it, but it's not.
Do you believe the court's compliance with Ms. Kroll 6.302?
I do, Your Honor.
Mr. Champion, you agree?
I do, Your Honor.
All right, the court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for this offense. Therefore, the defendant is found guilty of count one. The habitual enhancement will be dismissed at the time of sentencing. One moment. Ms. Hall, this case will now be set for sentencing. Typically, that's done in about 4 to 5 weeks from today's date. Between now and then, an agent from the Department of Corrections is going to prepare what's called a pre-sentence investigation report. Based upon the criminal history I see here, you've had some done in the past. That report will include a description of the offense, description of the pretrial agreement, any statements or information you make or provide while it's being prepared, as well as information about prior criminal history, performance on bond, performance on probation, performance on parole if you ever had a prison sentence. It will also include a recommendation as a sentence, and it will include a score in the Michigan sentencing guidelines. I highlight for you that the guidelines are not mandatory. However, they are a tool the courts must use to determine an appropriate sentence. Also, that the recommendation is merely that. It is a recommendation, as it is the court alone that determines the sentence based upon the information in the report and that's presented by the attorneys. You understand?
Yes,
There are 3 steps that involve you. Number 1, you're going to get a packet. You're going to complete that packet and turn it in. Number 2, you'll be subject to an interview with an agent from that office, and you have the right to have your attorney present during that interview. And number 3, Mr. Champion, once the report's prepared, which is generally about 2 weeks prior to sentencing, he'll go over it with you, and each side has the right to come back to this court and request corrections or make objections to the contents of the report. Do you understand?
yes.
Thank you. Mr. Champion,
Yes, Your Honor, we would like to respond.
go right ahead.
Since Mr. Ringstone has already stole my thunder about 7411, this is my client's first conviction of any type. She's taken responsibility. As we've heard, she's been very honest and truthful.
Does she have a bed available?
She has a bed available on January 8th at New Hope in Sault Ste. Marie.
All right, any objection, Mr. Ringstrom?
No objections, and I'm sorry I stole his thunder.
That's all right. You got to do it once in a while. The court grants the bond modification. The bond modification is as follows: that on the morning of January 8th, the defendant will be released from the Milwaukee County Jail. She'll be transferred from by the Wex Express to the treatment facility. And it will be, I can't remember, I already said it's a PR bond. She must participate in the program. If she leaves the program unsuccessfully or is terminated from the program involuntarily, then she must report back to the jail immediately. If she is successful with the program and completes it, then she can continue on a PR bond and will be subject to random testing, as she's not to use or possess any illegal or controlled substances, which includes recreational marijuana and alcohol. And that testing will be done by the Wexford Missaukee Community Correction Program, which is housed over in the Wexford County Courthouse building. While she's at that facility, she will sign a release to allow community corrections only to monitor her attendance. What that means, Ms. Hall, is they don't get to find out what kind of juicy secrets you're talking to counselors about. That's all private. All they get to do is say, hey, is she there? Good, thank you. That's it. Okay?
Okay,
Nobody, I don't want you to feel like I'm gonna find out, or anyone else outside of you and your private relationship with your counselor is gonna invade that privacy. We just want to make sure that you are where you are, okay?
Okay,
Now, these programs generally include a 30-day or up to a 30-day inpatient, and then they generally include some outpatient programming and sober living facilities. Whether or not you do those is up to you. But as I'm sure Mr. Champion will tell you, you want to do them. I'll probably adjourn my sentencing to allow you to get the maximum benefit of that programming. And you have, according to this, a guideline range of 10 to 23 months.
mhm,
I could easily send you to prison. I could easily give you a year in jail. How you handle your period of probation, and really not probation, your bond, but really what I want to talk about is how you handle this opportunity for you is critical. Okay?
I
Yeah.
understand.
Yeah, so
Thank you.
if you leave the program unsuccessfully, you are throwing the keys to the jail cell back into my hands. Got it?
Yes,
All right. I don't say that to be rude. I don't say that to be negative. I say that to say, hey, let's take advantage of this opportunity because we all hope for the best for you, okay?
thank you.
All right, all right. Anything else, Mr. Ringstrom?
No, Your Honor.
Anything else, Mr. Champion?
No, Your Honor, thank you very much.
Will your office submit the order for signature?
I will.
Thank you very much. We are adjourned.
Thank you.
Thank you, ma'am. All right, do we have Miss Runyon yet? All right, why don't you guys tell me if we have anything to put on the record for a final pretrial conference? We have any pleas? That's what I need to know.
I just 2 minutes.
You've got 2 minutes.
That's all I need.
It's okay. That's all you get it. Mr. Harrison, do you have any of these? I don't see your name on any of them.
Involved with Mr. Ford today.
We are moving on to people of the state of Michigan versus Jason Lee Ford, file numbers 25-3634 FH. Appearances, please.
Thank you. I'm David Denhout on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Ford. He's joined me at the table.
Thank you. You may be seated, sir. We're here today for a final pretrial conference. This case is currently one of those set for trial on January 20th. What are we doing with the case today, Mr. Denhout?
Your Honor, if I may make the formal plea offer, put
Sure.
as part of the record, Your Honor.
Yeah.
The people are proposing that if Mr. Ford pleads guilty to count 1, domestic violence as a third offender under, or no contest, guilty or no contest under MCL 750.815, that then the people would be dismissing the HAB fourth notice.
You said that's a DV as a what? A
DV third, yes. Your Honor.
Okay, thank you.
5 years.
Yep, Mr. Harrison?
That is an accurate statement. We're aware of that offer, if you will. The point of negotiation, that's where it broke down.
Okay.
There is no resolution today. We're prepared to go to trial.
All right, thank you very much. One moment here. All right. Mr. Ford, I don't remember if we've talked about this before, so I'm gonna go over, I say something every time I have a final pretrial conference. And when I do, I make sure the defendant understands, do not take any pressure or encouragement from me as to what you ought to do. I don't know anything about the case other than the charging document. So what I tell defendants is today is the last day to enter an agreement less than pleading as charged. Yes, sir?
Can I take one more minute, Mike?
Sure.
Please.
Yeah.
I'm thinking.
You're okay. But hold on. Let me get this out so I don't forget.
Yes, sir.
So the reason why I do this isn't to force a defendant to enter a plea or to take a plea. It's really to force the attorneys to do their job. And it's to force them to negotiate to the best they can. So what they're telling me today is, barring whatever happens here in a moment, Judge, we have argued, wrestled, Indian wrestled, took each other down, threw punches. We can't get any better of a deal. Therefore, Judge, we know the deal won't change. And then I say, today's the last day to enter a plea. And if you don't, that's okay. But now I have to say to the other cases that are all, I've got 8 cases set for trial that day. I have to move all those. And we have to call in 60 to 90 potential jurors. We'll have to take time off of work and get somebody to take care of the kids and somebody to take care of grandma. And we've got to subpoena witnesses for both sides. And so I don't do this so much to, I'm sorry, I don't do it at all to force the defendant, but I do it so you and I know these two lawyers out here have done all they can and they haven't wasted our time, and we are doing a trial. All right, that's why I do it. Plus, again, I'm sorry, no, that's it, just to make sure they've done their job. I know nothing about the case other than what the charging document says. I have nothing, I have no idea what the witnesses would say, what the evidence would be, what it won't be, but I just have that policy. You may take a couple minutes.
Thank you, Your Honor.
Thank you. We'll go ahead and recess, and we'll come back here in just a moment. And in the meantime, we're going to jump backwards and take care of the case of People of the State of Michigan versus Loretta Runyon. File numbers 25-3631-FH.
Your Honor, Mr. Ringstrom, the assistant prosecutor, was handling this file. There was an emergency last-minute hearing scheduled in probate court that he's currently conducting in the other courtroom. I'm respectfully requesting if we could pass this, just temporarily, Your Honor.
That's fine with us, Your Honor. We appreciate the court working with my client's schedule today as well.
Okay. We're gonna find a moment to send. I don't know Zen. Anyways, all right, we'll take a brief break. But I'm going to jump on to another case. Let's get Mr. Champion. That's right. Go back and have a seat. I know, by the way, I don't hold anything against you. I know it's a snowy day out there. Thank you.
Thank you.